Hi, I'm Paul Vacheski, Nebraska Landlord.com, and we're continuing our series of videos on the Nebraska Landlord-Tenant Statute. So today we're going to be talking about access, or in more particular, the landlord or property manager's access to the property. This comes from Nebraska Revised Statute 761423 that outlines the requirements for that access. So the first thing we have to do is the landlord property manager must give, the statute says, a 1-day notice. Now, a lot of people think this is 24 hours. It actually doesn't have to be 24 hours. The statute says 1 day's notice, and it has to be at reasonable times. So let's kind of package this together here. So let's say, for example, the tenant calls you at 3 p.m. today that they need some kind of maintenance work done, and you can get to it tomorrow at first thing at 8 a.m. That would be considered a reasonable notice that was given. It's 1 day and at reasonable times. Reasonable times typically means somewhere between 8 a.m. and 5 p.m., but also that could be a little bit different too. Let's say, for example, that the tenant works the third shift, so they work all night. A reasonable time might actually be in the afternoon. So kind of keep that in mind when you're developing your process and your systems for your notice for access. But again, the statute says a 1-day notice, and a lot of times that's going to be determined between you and the tenant as you work out the times of entries. The reason that we may need access to the property during tenancy may be to show the property to prospective tenants. Maybe the current tenant is on their last couple of months on their lease, and we're starting to show it to new tenants. To inspect the property, obviously as the property owner or the manager, you have a right to inspect the property most of the time on an annual basis. Some people do it every 6 months. And then also to let contractors in, like the plumber, the electrician, to perform any kind of maintenance that has to be done. Again, 1-day notice and at reasonable times. Question I get a lot is, how do we deliver this notice to the tenant? Now, many property management companies have a process that they do, but let's say you don't have software and all the process like the bigger management companies do, then you have to deliver notice in accordance with what you agreed to. Now, for example, put in your lease or your community rules and make sure that your tenant gets a copy of how they are to request maintenance, those type of items, or how you deliver notice to them for access. Make sure it's in the lease or the community rules. Question I get is emails, text, is that okay? It depends. If it's in your lease agreement for what I call minor notices, and I would consider access to the property a minor notice, texts are okay as long as the tenant and the landlord agree to it, and you want to make sure that it's agreed to in writing, i.e. in the lease or community rules. Email is a very common way to deliver notice of maintenance and those type of things. So again, if you don't have anything in your lease agreement or your community rules indicating the method of delivery for these notices, then you have to default back to the statute that says hand delivery or through the first class, through the mail system, United States Postal Service. So we want to make it as efficient as possible. Emergency situation, the 1-day notice does not apply if it's a true and actual emergency situation. So maybe there's a pipe that's broken. You don't, obviously, the property is at risk of suffering substantial damage, then you don't need to give the 1-day notice. You have the right to immediate access. But don't abuse this. This is for legitimate emergency situations where the property could suffer substantial damage. And the last thing is, what happens if you give notice? Maybe you want to show the property to a prospective tenant, whatever, let a contractor in, and the tenant says absolutely not. Well, first of all, I would remind them of the agreement, the lease agreement, and what they agreed to. And just say, I'm going to be there, I'm giving you proper notice, I'll be there tomorrow at 1 o'clock or whatever it is, and the lease gives me permission to do it. So always kind of give you want to tell your tenant that, no, this is going to happen, read your lease. If you get there and they absolutely refuse entry, then you cannot enter. If you do, doesn't matter what the lease says, then you risk actually a criminal citation for trespassing. So if the tenant is hostile and they're absolutely non-compliant, then what you, under the statute, have to do is actually get an injunction. So that means you're going to have to call your attorney, get an injunction, and that basically forces your tenant to give you access to it. And then if they don't, there's some legal remedy that you have there, and there's some legal consequences for your tenants if they violate the judge's order. So that's basically landlord's access to the property in a nutshell. If you have any comments, any questions, anything at all, please make sure down below you leave your comments. On YouTube, make sure that you subscribe to our channel so you're notified anytime we have a new video that's coming out. Like our Facebook page. We really want you to engage our audience and our community, because that's how we all get better. Until next time, happy landlording.